So thank you so much for joining us for today's session on the rights of disabled students, hosted by the Snowdon Trust Disabled Leaders Network. As you will hopefully be able to see, for this session, we have live captioning provided, and we also have BSL interpretation. So if you need BSL, and I can see there is a question in the chat. So if you need BSL, you should be able to pin them on your screen. So we have Paul providing BSL and Rebecca providing BSL. They've both just come on camera, so you should be able to pin them on your screen so that you can see them. But if you have any issues, please just write in the chat and we can work with you to work it out. So yes, we have captioning and BSL, and this session is being recorded, but it is in a webinar format. So if you are in the audience, you don't need to worry, you're not being seen or heard. It's only the speakers who are being seen and heard. So you can relax. And if you have any questions throughout the session, please do use the chat to share your sessions. And when we come to the Q&A section, you should be able to raise your hand and ask questions that way as well. But if not, you can use the chat and we will make sure we give plenty of time for questions. So I think a lot of more people have arrived now. So just to give you a little visual description, my name is Amelia and I am a 20-something white woman with blonde hair sitting in front of some bookcases, and I will be kind of hosting today's session. So this session is focused on the rights of disabled students, and for those of you who do not know, the Snowdon Trust Disabled Leaders Network is made up of exceptional disabled students, graduates and early career professionals and academics, and we really try to provide a community for us to support one another, for professional opportunities and networks. And one of our key aims is to advocate for inclusive higher education. And so this event today is kind of part of that work that we do, and we really think it's important that disabled students know their rights and know the processes that are already in place, so that they can utilize them to their best effect, as well as obviously we recognize the need to push for further change. But in today's session, we'll be focusing on kind of what already exists and how you as disabled students can utilize it. And if you are attending as someone from a university who supports disabled students, we hope that today's session will kind of give you a bit more information about the processes and the legal rights and all of that side of things. So we have, speaking today, we have Chris McFarland, who is a wonderful lawyer from Sinclair's Law, and I think he will do a better job of introducing himself. So I will leave the main introductions to everyone when they speak, but we have Chris McFarland, we have Anna Freed, who is a member of the DLN and a recent master's graduate, and then we have Julianne, who is a member of the DLN and who is currently doing her PhD. So we're really looking forward to hearing everyone's perspectives, and I will now hand over to Chris, but please do share your thoughts and comments in the chat as we go along and introduce yourselves, and then we'll come to questions at the end. So thank you.
Thank you very much, Amelia, and thank you very much to the Snowdon Trust for inviting me here today. So yes, my name is Christopher McFarland. I'm a solicitor and director of Sinclair's Law. I am a white man in his late 30s, increasingly later 30s, with a beard and glasses, and I have a blurred background as I'm in the office today, but lovely to be here. So I will be talking about the rights of disabled students under the Equality Act and giving some practical tips on how students may self-advocate for those rights, or how they may go about seeking support to advocate. I do have some slides prepared, and I have confirmed to the Snowdon Trust they can be circulated, but it'd be helpful, I believe, Louise, if you could share those slides for me. I'll try and talk people through them. To those who are using BSL, if that adversely affects your ability to see the interpreter, please do let us know and we'll try and take alternative steps. Okay, so just say that in the chat. So self-advocacy and the right of disabled students. So if you can go to the next slide, please. We start with when is a student disabled? And in legal terms, it's when they satisfy the criteria of Section 6 of the Equality Act, which is a person has a disability if they have a physical or mental impairment, and the impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. Okay, this is called the functional test of disability, where when a person is disabled is not necessarily determined by the nature of their impairment or necessarily by a particular diagnosis, but whether or not it has that substantial long-term adverse effect. Okay, long-term is also defined as that it's either lasted for 12 months, is likely to last for 12 months or more, or may last for the rest of the person's life. And there is also grounds within the Equality Act to confirm that if you're someone who has maybe more of a chronic disability, so say if you have Crohn's or something that may have periods of relatively well health versus then relatively difficult periods of ill health or disability, that you are disabled for the entirety of that period. So the likelihood of recurrence actually means that long period. So don't have anyone tell you that, you know, if you have a condition like that, that you're not disabled because you have times when you're well. That is not a requirement for the test. If we can move to the next slide, please. So we're now talking about the duty to make reasonable adjustments. So for disabled students, this is often something they hear about, but maybe not something they fully and completely understand. And that's also the same for those working at universities, which is sad for all of us, as we'll come on to. But under Section 91(9), it's technically the governing body of the university that has this duty, but it's the university as a whole has a duty, and that's defined by Section 20 and is comprised of 3 different requirements. The first is where a provision criteria of practice of the universities, sometimes known as PCPs, provision criteria and practice, puts a disabled student at a substantial disadvantage in comparison with those who are not disabled. The duty is to make such adjustments that are reasonable to mitigate or avoid that disadvantage. The second requirement is where a physical feature puts a disabled person at a substantial disadvantage. So if you're a wheelchair user, the need for a ramp and other such arrangements that may be required for other physical disabilities would come under the second requirement. And when it comes to the third requirement is where, but for the provision of an auxiliary aid. So here we have a perfect example of that with our BSL interpreters now, okay, where obviously if you are a person who has difficulty with hearing and that you are a BSL user, that having BSL interpretation or BSL support for things like lectures or other events where you would need to interpret that language or another adjustment, again, live captioning, another way of doing it, but that's an auxiliary aid. It's something that you need to be given to avoid the disadvantage that you would have, which is the difficulty in interpreting the language without it. Okay, so those are the 3 requirements, and a failure to discharge any of those 3 requirements, either individually or cumulatively, is a form of disability discrimination as confirmed under Section 21. Okay, next slide, please. So freedom from discrimination. Now I've grouped these all together, firstly for time, but also it can be quite difficult to really go through these individually without good examples. But there's also a series of prohibited conducts that are prohibited in respect of all protected characteristics, of which of course disability is but one. So this would also occur to those who have rights for race, religion, even things like maternity, gender reassignment, etc. Those are also protected characteristics that have these protections. The duty to make reasonable adjustments is exclusive to those who are disabled. It does not apply in other contexts. Okay. I think I've had an excellent bit of guidance there from Rebecca to say it's fine to say deaf or hard of hearing. Thank you for that point of guidance. As I say, I did not want to inadvertently say something untoward, but quite right to remind us we can always learn to be a bit better with our inclusive language. So thank you very much, Rebecca, for that guidance. Very helpful for me. So in terms of direct discrimination, that's where you're put at a disadvantage as a result of your protected characteristics. You are mistreated because you are a disabled person. So again, someone treating you adversely, excluding you from something because you're disabled, thinking that you are maybe less able because you are disabled. Again, all of those things. Discrimination arising from a disability is somewhat different to direct discrimination, in the sense of it may be discriminating against you for something that arises from your disability rather than directly the disability itself. So, for example, one of the famous cases of this is that with regard to an autistic pupil at a school, this was a primary school. When she was supported to meet her needs, she was regulated and calm and relaxed. But if whatever reason there was either something that arose unexpectedly or her needs were not properly met, she would dysregulate and could lash out in a way that could be violent. And there is a restriction, there's actually an exception on violence being, or a tendency towards violence being counted as a disability. So they would say that where they excluded this pupil for lashing out when she was dysregulated, that was lawfully permitted because there was an exception under the regulations to allow that. Well, that got considered by the upper tribunal, and they said that's not the correct interpretation, because the tendency towards violence was not in and itself the disability, but her lashing out in times of dysregulation arose from an underlying diagnosis of autism. So again, where they were excluding her, which you still technically can do, even if the person's disabled, you had to fulfill the criteria under Section 15, was that it was a proportionate means to achieve a legitimate aim. And on the facts of this case, it was not proportionate for there to be an exclusion. There were other lesser sanctions that could have been used to try and help everyone learn from that process, and of course, more support needed for that child. Indirect discrimination relates primarily to, again, policies, criterions, or practices that, again, may not be intended to discriminate against anyone, but may have a discriminatory effect. So again, this may be, and it can be all sorts of things, but if it's arranging certain events that may be inaccessible to those, again, you would have a duty to make reasonable adjustments. It may also be prohibitions on certain things that ultimately are reasonable adjustments. You often see those two rights kind of come in tandem, because often the first requirement and indirect discrimination do have a similar overlap. But it's things like that where a policy is getting in your way and the university feels it's bound by the policy, but by being bound by that policy, it's resulting in adverse treatment for the individual, which is of course not appropriate. Harassment is where, again, someone is essentially harassed for their disability. This could be language or conduct that, again, is used to demean the individual as a result of it. And victimization, which is if you make a complaint that your rights under the Equality Act are not being upheld, but yet you're treated to an adverse consequence. So I had a student client many years ago now, about a decade ago now, who she'd made a complaint about sexual harassment. Now, the facts were a little bit niche, and the universities felt that in that instance there wasn't sexual harassment. They found against her in the complaint. But the problem wasn't that they found against her on the evidence. The problem was that they had, in fact, opted to then go further and exclude her for what they said was a false claim. And so I wrote to the university, said, you can't do this, that's victimization, because although you didn't find in her favor, you said the facts were, the case wasn't proven, you didn't find that it was a malicious claim. So it wasn't something she said a falsehood. In many ways, it was, her interpretation of the events was completely genuine, even if you didn't find it. So you can't get rid of her. And ultimately, they had to concede that that was the case too. So victimization can be very powerful and is there deliberately to protect people so that they can feel comfortable and protected to raise concerns, to the university without fear of repercussion. So moving on to the next slide. So I do apologize to everyone. That is a little bit dry when we talk about the law there, but it is important as a lawyer that we run you through all of the actual legislation here, and the slides will help you refer to that, okay? So how do you actually go about this in practice, which I think is the most helpful for a lot of you? Well, there are procedures at each university. Universities are required to have procedures for supporting disabled students. They'll normally have a department as well. So you can normally get these regulations on the internet, but also there's normally disability student services that can help you with that as well. Okay, there are some limitations because often they require the students to identify themselves. So even though there is a proactive obligation on the university to anticipate, called an anticipatory duty, that disabled students will use their services, functionally and in practice, they obviously will not know and will never assume that a person is disabled. So of course, it's often the case that if a student does want support, they need to self-identify, which is one of the weaknesses of the system, because even if difficulties are run into, sometimes staff feel like they shouldn't, either it may be insulting or possibly even discriminatory to think that a person should be assessed for a disability if they're running into difficulty. So you tend to find this situation where students need support but aren't getting it. So that's a weakness. Well, and as well, it's often that the student will require to submit to an assessment and then a disability support plan to be circulated to relevant staff as well. So if we move to the next slide. So some of the difficulties our clients come into are somewhat, I say, that they're overly procedural and bureaucratic. They're difficult to navigate, and really it can be quite challenging to know where to begin. Sometimes students can find the forms intimidating. Again, particularly where you're talking about something that's very personal to you, how your disability, impairs you, because we have to talk about that under the Equality Act. What are the challenges that you're facing? How can you be helped? Often students do feel maybe embarrassed, not that they should, but they do. When we're talking about ourselves, it can feel embarrassing. And of course, it can be very difficult to know how to fill out those forms correctly. So that can be very daunting for students. Students have found the support offered is standardized. So sometimes, as I give in the example there, getting extra time for an examination, that seems to be a fairly standard adjustment. So even though it's not always easy, again, if you have, say, a specific learning difficulty or something that does need that extra processing time, universities have gotten used to being equipped to that. But where, and we come on to this with the Abrahart case, where in fact it might be the method of assessment is actually the issue, where something a bit more bespoke is required. That can often be where students hit hurdles, where universities feel they can't do more than the standard adjustments, which is not what the law says at all. And again, we talked about the purpose of the disability services to prepare a plan so it gets circulated. So for any of you who had a statement or education healthcare plan or an IDP in Wales when you were in school, that's the whole point. We set out in the document how we help you, and everybody knows it. And if we have any questions, we go back to that document. It makes life easier because the disabled person is not always having to explain themselves, because again, that's not a dignified way. We don't want them having to communicate very personal things to every teacher and individual they meet. That's what this document is for, is that we know what you need, everyone's going to see it, and everyone knows they have to follow this document. But again, in practice, we sometimes find that it's not being circulated, or the teachers don't know it. And then again, the student is left having to advocate for themselves when really they shouldn't have to. They've done the steps there. And again, it's about review. So sometimes students, they put on their application form that they're disabled and adjustments are made. And then they actually start using them. They realize that some of the adjustments don't work as well as they'd hoped, or maybe more adjustments are required. But then there's no review process taking place. They never asked if these things there. And sometimes students may feel that they shouldn't ask for more. Maybe, oh, I've got everything I can. Am I going to come across, basically rudely? And I've just seen, and your feedback there. I will try to slow down. I apologize. I'm a Welshman, and I understand as Welsh people we speak quite quickly, so maybe it's that. But I will try to slow my tone down for you. But again, like with review, sometimes we need to plan, do, and review. If something isn't working as hoped, or something different or better may come along, then of course you should do that. So next slide, please. So this is the case of Abrahart and University of Bristol. You may have seen this in the media. It's a tragic case where, very sadly, Natasha Abrahart, who had mental health difficulties, took her own life, in part because she was very distressed about her examinations at university, and particularly the method of examination for her physics degree, which required her to give an oral presentation. Natasha did have other difficulties outside of the university process, but it was clear on the evidence that this was causing her particular stress. So her friend took her to the university to her professor to explain this, and they said they'd look into it, but it kind of fell between two stools. The professor wasn't sure who to refer to Natasha to. Natasha was very reluctant herself to talk about her difficulties. Her friend literally had to force her to say anything to begin with. And then very, very tragically, obviously, she took her own life before any adjustments were made. So this went to the court. Her parents took this case feeling that she'd been wronged by her university and that had contributed to her death. And the judgment, and there's two long judgments. It went to the county court and the high court, but these were the two key points that I think came out of it, which was, for the avoidance of doubt, it was not necessary for Natasha to identify reasonable adjustments at the time. If there was a duty to make reasonable adjustments in the first place, then it was for the university to apply its mind to the adjustments that could be made. And this came out of the fact that, again, like I said in the previous slide, when Natasha was identified as having mental ill health and needing adjustments, they then turned around and said, okay, how do you want us to help? And Natasha just was not able to convey that. She was struggling. And so the university said, well, it's not our fault. She never told us what she wanted. And the court said, no, no, no. You did know she was struggling. You knew she was disabled. You, university, have to make it work. It's your job, not hers. And you can't hide behind the fact that she couldn't communicate with you about this or didn't communicate with you about this. And the second, where it says, insofar as the university argues that it made any adjustments, and as covered earlier in the judgment, I find the university did not get that far. Again, they were kind of stuck in that bureaucratic process, as we talked about. We know that Natasha's substantial disadvantage compared to a non-disabled student remained, and as per Archibald and Fife Council, which is a 2004 case, the duty to make reasonable adjustments could not be said to have been complied. So what he says there is, as we say about review, it's okay to have a good start in an idea, and it's okay to say to a university student, we're going to try this. But if that doesn't resolve the issue, you've got to go again. You've got to keep it under review. And they clearly didn't hear. The High Court case was decided on slightly different grounds. But ultimately, these points were vindicated. And I think the key issues is that it is for universities to make the adjustments and not the student's job to tell the university what to do. Next slide, please. So practical steps. And again, I think that, again, the legal issues are great and all the legislation is fine to hear, but how can we help people in the short term? If you know of someone in difficulty or you're in difficulty yourself, how do you get from where you are now to hopefully a proper solution? So if you have or believe you may have a disability, you should approach the disability services team. They're the people who will have the resources and the knowledge in the university to help you and should always be your first port of call. If you're uncertain about how to do this, the student union can sometimes help with advocacy to do this too. So if you are worried about conveying your needs, they can help you. If you go to disability services and they don't provide you with any support, or if the support they give you feel is inadequate, you may be able to raise a complaint. Hopefully that won't be required, but it's important you have the right to do that. There is a complaints procedure your university will have, and you can ask for this and complain in accordance with that. Again, the student union often helps students raise complaints or appeals if they are entitled to do so. And then finally, if you're unable to obtain additional support through the complaints procedure and/or the student union, then at that point it may be advisable to get legal advice. Obviously, at the end of the day, there can be claims in discrimination brought against universities. It is always best to try and resolve through these steps first, because firstly, they're free and legal advice is not always free if you don't qualify for legal aid or if you can't find a legal aid provider. But also, it's good that you want to preserve the relationship where possible. Sometimes, as in all walks of life, things do go wrong, and the university may want to sort this for you if they're given the chance, but you need to give them the chance first. And very finally, the last thing there is a time limit to bring a discrimination claim, which is 6 months from the date of the discriminatory acts. So you do need to act promptly and make sure you are taking any advice with enough time spared. I believe that's all my slides, but if you could just check to the next slide, please. There you are. There's my contact details. If anybody does have any queries, please let me know. I think that's my time, but Amelia, I'm not sure if there'll be time at the end of the talk for people to ask questions, but thank you all for listening.
Thank you so much, Chris. Yeah, I might just come in with a few of the questions that will come through now, if that's okay, that were just particularly pertinent.
Absolutely.
So someone has asked, is the 6 months time frame, is that movable?
So there is some provision if there's a continuing act of discrimination. So i.e., particularly if it's direct discrimination, if they exclude you from something because you're disabled, and then 3 months later they do the same thing in a different context, the 6 months would almost restart at that new stage. But I have to note a lot of caution here. That is often very risky as an approach. So you should be taking advice early. And when it comes to reasonable adjustments, a failure to make reasonable adjustments is not considered an ongoing breach. So the case law says that the university should be given a reasonable period to implement the adjustment, which again, depending on the scale of it, obviously if it's a physical feature, they might need to get builders in, planning in, depending on the scale. So it may be longer that they're allowed to put that in. If it's an adjustment for an exam coming in May, if by April you haven't got any confirmation of this, the time of there. So your time limit will start to run from that point, and that's very difficult to interpret, and it'll be up to the interpretation of the judge. So the reality is you are always best off taking the first act of discrimination and getting advice within that 6 months, because everything else turns on the facts of your individual case. So really only a lawyer can properly advise you whether, yes, we think you've got longer than you think because these other acts will restart the clock, or no, we need to go now because if we don't go now, that first act is going to be out of time.
Thank you. That's really helpful. Another question that's come in is regarding accessible student accommodation on campus. Kind of what is considered reasonable in the provision of this, and does that extend to accommodation not under the control of university? And I think that's something that a lot of people have questions about.
Yes, so if the accommodation isn't under the control of the university, then it won't be the university's duty to make reasonable adjustments. Again, it would depend on the nature of the service offering that accommodation, whether or not it was reasonable. In terms of the university's obligation to make reasonable adjustments, the university should be offering disabled students accessible accommodation. However, again, in practical terms, there is the limit of the duty to make reasonable adjustments is that question of reasonableness. So, of course, if in a particular year the number of disabled students requiring access arrangements exceeded the number of accessible rooms available to the university, it would not necessarily be expected by the court that the university would be able to, in short time, either amend rooms to make them accessible or build completely new ones. So it is challenging, but certainly you should always raise with the university if you don't have an accessible living arrangement, particularly in their own accommodation, because they should be able to assist you.
Great, thank you. And then we've had a few questions on diagnosis and medical evidence, and sort of if you could just elaborate on a bit more on whether that is necessary, and kind of how that fits in with the functional knowledge of disability.
Absolutely. So, as I say, legally speaking, it isn't necessary, but in reality, it is extremely helpful because, of course, it can be very difficult that for universities to necessarily know if a student's disabled. That's why they often have assessment services available to them, because again, you can't assume someone's disabled. And of course, as people who've worked with or have any knowledge of disabilities know, people are individuals. So you may have, for example, with autism, we know that that's a spectrum. So for some people, they need certain adjustments, but even if they're both autistic people, the next person may require totally different adjustments. And one may find the other's adjustments totally unsuitable. So you do have to bear that in mind. So it's always very helpful to have medical evidence, and practically speaking, it can mean you get your support quicker. It isn't strictly required, but as ever, sometimes being right is always helpful, and it's important to know you have your rights. But if that's going to mean that you being unwilling, let's say, to go out and go to your GP to get some evidence or trying other services, if you were someone who said, I'm not going to get medical evidence at all, then you may find that you're just waiting a lot longer for your support. So if you have evidence, then please do share it. It's very helpful, but it isn't strictly speaking necessary.
Okay, great. Thank you, Chris. I think there's a lots more questions coming in, but I think maybe if we come to them at the end, if that's okay.
Absolutely.
Perfect. Thank you so much. So
Thank you everyone for your questions as well.
and if you feel free to write anything in the chat, Chris, if you find that easier as well. So I will hand over now to Anna, who is a member of the DLN and who will be sharing kind of from her own personal experience what she's learned and kind of some advice and some examples of good practice at universities.
Thank you, Amelia. I thought I'd just add on the accommodation thing that was mentioned. When I received disabled students allowance, I was told by the DSA providers that your university does have a duty, if you're a recipient of DSA, to provide you accessible accommodation throughout your undergraduate degree. Just might be useful information that I hadn't included in my slides. But hi all, my name is Anna. My pronouns are she, her. I'm a member of the Disabled Leaders Network, and I graduated from my master's at the Sainsbury Research Unit at UEA in October. I cannot see the slides. Can other people see them?
No, we can't.
Okay.
I think Sophie's just sorting it.
Sorry about that. Let me try again.
But to give a brief sensory description, I'm a white woman with long brown hair, wearing a grey top, and I speak with a southeastern English accent. And as Chris made clear, self-advocacy shouldn't be the expectation, but my part of this event is giving my own stopgap measures and an overall positive experience. I also resolved a harassment complaint informally at university, so if people are interested in how that can work, I can discuss it in the Q&A. As the slides still aren't sharing, should I? Oh.
There, can you see them now?
Yes.
Yes, okay.
Okay. Sorry about that. If you could go to the next slide, please. So, as many postgrads will have experienced, support processes usually change between undergrad and postgrad, even if you stay at the same institution. For me, I changed institutions and it ended up being great. At undergrad, I had fewer needs, yet it was more challenging to get simpler adjustments put in place. Evidence burdens were higher for all forms of adjustment, often needing specialised GP letters and having to chase adjustments. At UEA, my department lacked any procedures for disabled students, which might sound bad, but it meant there wasn't any policy binding staff's kindness. I was able to get adjustments put in place informally without chasing or evidence, and I only needed evidence for central university processes. UEA's centrally led inclusive design was also really helpful. Like my exams were already entirely accessible, and whilst at undergrad, coursework extensions of any length required central committee approval that took 2 to 3 weeks, UEA had auto-approved 7-day extensions for everyone, and I also got a further 21 days because I had evidence held by the disability services. And both institutions, I had wonderful staff advocates, but only one of those procedures felt like it was built on trust, and only UEA had a culture where teaching staff could genuinely encourage rest and celebrate small milestones with me, like attending my first full seminar remotely 3 weeks post-op versus having to focus on me being quote unquote behind. Next slide, please. Amelia wanted me to discuss non-standard adjustments because from the student side, it can be hard to know what is feasible. And as Chris said, not necessarily our job to figure out those adjustments. But I've separated this into exam and non-exam, and it's worth stating that what's completely standard at one university might be non-standard at another. So don't feel discouraged if what would make something accessible to you isn't a typical thing at your institution. I would always start by thinking about what would fix the problem in a dream scenario, figure out whether it's feasible, and then decide whether you want the adjustment to be formal or informal. A worked example from my experience was reduced formative workload for a term at undergrad. I struggled in COVID lockdowns to work at home due to my disabilities. I knew this was something I could fix anytime soon. So most intuitively, if I can only do X number of essays at home, I can let staff know to reduce burnout and stress. So I reached out to staff I trusted, who said it was sensible and feasible. I emailed the relevant staff, they agreed, and the adjustment was put in place. And it's worth noting that this super bespoke adjustment at undergrad is something that was entirely standard at UEA. Other non-standard adjustments I got across my degrees included hybrid sessions, accommodation with a smaller shared kitchen, catch up on multiple lectures with a lecturer or supervisor, and extra long extensions. Next slide, please. When it comes to exams, things can be a bit more complex because degree results are understandably a more fraught topic for universities, especially when it comes to what's perceived as fair. They usually require more evidence, often that is more tailored to context, like a specially written GP letter. So I thought I'd focus on a concept guiding exam adjustments, which are called competency standards. Essentially, this describes what a degree or assessment is trying to judge, and anything that isn't a competency standard can be altered to remove a barrier for a disabled student. This is why exceptions around spelling, punctuation, and grammar can exist for disabled students in many exams, because an exam is rarely trying to assess how well you can spell without a spell checker. However, competency standards change with context, like changing a timed essay to a take-home exam is often fine, but changing a translation exam might not be, because testing your memory of the language is a core competency they're trying to assess. A couple adjustments I've seen in my time include replacing an exam with a coursework portfolio, making it a take-home exam, making the assessment window longer than typical extra time would give you, or making an in-person exam remote, which I did have. A big caveat here is this term, like many ideas in these things, are ambiguous, and neither you or I can definitively say something is or isn't a competency standard. But I thought that knowing this concept can be helpful when trying to figure out what might be realistic for you. Next slide, please. Moving on, I thought I'd talk a bit about what I found helpful in self-advocacy, and a huge disclaimer, of course, that you could be the best self-advocate in the world, and you might still face issues, and that's when the other talks in this session become especially relevant. The thing I found most helpful was proactive emailing and disclosure. I always declared my disability with disability services at teaching staff. At undergrad, I had an email template where I introduced myself to teaching staff, attached my disability services document, and gave a summary of what's relevant to them. It made I knew everyone was aware of my needs, and made me more confident when I had to let them know I was absent or needed an extension. I had several staff members say they found it really helpful to have a student-led interpretation of what's often a document based on templates that they've seen a ton. And being able to raise things directly with staff also made my life easier at my master's. I only had to reach out to central services about exams and accommodation. Everything else, like hybrid access, was organised in a quick email exchange. Of course, if you're not comfortable disclosing to teaching staff, it shouldn't be expected, and staff in your department may need more official cajoling than mine did. I just found it helpful. Another thing I found helpful in the face of resistance was the gentle introduction of legal jargon into your conversations, not going outright saying this is illegal, but more, I was asking for this as a reasonable adjustment for my disability, and explaining how it would help. It signals to them that you know the rights that Chris discussed in his talk, and gives them the opportunity to more diplomatically resolve things. And when you need specialised evidence for specific adjustments, I found it's worth remembering medical professionals usually don't know the wording and information universities are looking for. So for me at undergrad, to get my in-person exam online, I had to emphasise a one-on-one exam invigilator wasn't enough, but that I wasn't so disabled I needed a leave of absence, and that a leave of absence wouldn't fix the problem. And what GP is going to know that they need to say all that. So I gave them the same explanation, asked them to make things explicit they might think was obvious, like COVID is here to stay. It's not inauthentic, because if a GP was asked these questions directly by the university, they would say the same thing, but that write me an evidence letter is just quite a vague brief for them. Lastly, I knew what needed to be covered in evidence because I'd read the policy from a university guiding the process. At UEA, I had a staff member who worked through my evidence with me to assure it was enough, but at undergrad, all I had was those policy documents and a disabled students organisation who had summarised them for students. Next slide. Which brings me on to my final slide, all the sources of support and advice for disabled students seeking adjustment, though I'm sure I've missed some, and also haven't mentioned legal and the Office for the Independent Adjudicator here. You have your typical sources of support, disability services, pastoral tutors, academic advisors, but also consider the complaint service because for their website or an informal chat may be helpful when trying to figure out how to best push for an adjustment and your options to escalate within the university. For me, the biggest source I'd highlight is student-led. Most universities have a disabled student-led society. They will often have resources, guides, email templates with uni-specific terminology, and often have support groups or online forums where you can hear from fellow students and get informal advice. The Students' Union should also have a sabbatical officer with qualities or welfare in their remit, and whilst they nor the society committee can usually take on casework, they can be good signposters. Some SUs will have paid staff who can advise on complaints and help with your individual case as well. Within your department, definitely consider your student reps and administrative staff. Again, neither can do casework, but they have a good bird's eye view of the department and the players within it. They may not always be helpful if they're overworked, but at UEA, the admin lead have genuinely very helpful tips like who actually answers their emails. For technical support, I wanted to highlight library staff. Some have an accessibility team who can help with scanning, copyright exemptions, click and collect, navigating the library, etc. And accommodation services may have a specific person familiar with disability access and law, and the same with residential or campus life staff who run social events. At UEA, the residential life helped me organise an accommodation change and also could help with moving rooms if I wasn't able to do it myself. Lastly, university counselling and clinic staff can sometimes help beyond their typical supports. Often they know services to signpost you to within the university and are sometimes able to provide evidence for those university processes that require it. Chaplains, lastly, at my miscellaneous, are another group who are there to help students of any religion, and at my undergrad, they were very integrated into referring to other university support services. Next slide. That's it from me. Thank you for listening. Happy to answer any questions. Sorry for going over a bit.
Thank you, Anna. It's really helpful for us, for you to have used your experiences, both good and bad. And I'm really sorry for the bad experiences, but we really appreciate you using that to help other students kind of know how to advocate for themselves. And I think you gave some really great tips in there, so thank you so much. And I'm sure we'll come to questions, and I'm sure people will have questions for you, but if we move on to Julianne now, who is another member of the Disabled Leaders Network, and who is going to share her own experiences of going through a complaints process and kind of some tips for when, if you need to take it to that stage, some kind of things to bear in mind at that more stressful stage, I guess.
Yeah, so hi everyone, my name is Julie Ann Fouché. I'm a PhD student, and just for a quick general description, it's wearing a navy blue sweatshirt. I'm a white woman. I have kind of brownish hair, which is sort of blurred into my background a bit, so I apologize. My room is a little bit messy because my assistant's dog was terrorizing us this morning in his time off with his soft toys. So I've blurred out that disaster zone for you. So I'm going to be walking you through kind of advocating for yourself at a university. And some of this is going to be repeating points that both Christopher and Anna have brought up in a more broad sense. And I was just looking at the chat and seeing some people ask questions about the steps that they would take to kind of, make change at their university or make or get things taken care of. And hopefully this kind of gives you that step-by-step guide in getting there, as making complaints can be very stressful and very complex. So if we can go to the next slide. Thank you. So firstly, seek help from other people. Don't go through this process by yourself. One of the first things that I did was reach out to my student advice place. This is a department that was nested within our student union, and they are not, even though they're within the university, they're not necessarily part of the university, and they work for the students specifically. So they stand kind of outside of the university process, but are woven into that university process completely. So their job is to know everything in a way, whether that's how to file a complaint, how to help with accessing disability services, how to help you access funding. They're almost like a living library of sorts, and I can't speak highly enough of them. I've gone to them for everything from I don't know how to get access to this building, and they'll somehow find that information. So I would try and find that service. They may be called something else where you're at. They may just be a department within your kind of student services, but I would kind of locate that person. They can also help you determine what the complaints procedure is and how to navigate that. Just because the complaints procedure, I think, as Chris pointed out, has a lot of steps. The forms can be very overwhelming. They are they ask you to disclose a lot of things. It can be very uncomfortable. And the advice place was great for helping me navigate, finding out exactly what I should be saying, how to say it, and how to best represent myself and my claims. Next slide. So within the university, there's usually a two-step process. There's a stage 1 and a stage 2. I will say that typically for, I guess, complaints that are around a vulnerable characteristic, they should automatically go to a stage 2, but your university may argue that down to a stage 1. You can pressure that back to potentially move to stage 2, but see where you're at. Your student advice place can also help give you some guidance on this, just based on what that complaint is and what the kind of nature of your complaint that you're moving forward is. It may need to go to stage 1. If it does go to stage 1, you will have the chance to take it to stage 2 afterwards. Make sure you stay on top of your deadlines, just because I think Chris mentioned this in terms of like that 6 month for legal reasons, which is outside of university complaints. But inside of university complaints, deadlines can be very important as well. So just make sure you're watching your deadlines on, oh, I've got to turn this in within 30 days, or, oh, I need to turn this in 2 months out. And having an advocate can also help you stay on top of those as well. Make sure you're keeping kind of things that are important documents or anything that you've collected evidence-wise offline and in a non-university email account. And one of the reasons for that is if you graduate in the time that your complaint is taking place, you could lose access to your university account, and then you won't have access to that data or evidence anymore. So it's always worth having an extra copy of that somewhere else, whether that's forwarding it to yourself, printing it, and putting it in a notebook. That was one of the ways I kept track of it. Next slide. And then the other thing too is if you're looking for evidence, perhaps maybe you have an issue with university, or maybe you have an issue with somebody within a department or another student. One of the things that I found really useful, and this was flagged up to me by another disability advocate, is an SAR and an FOIA. So an SAR is a subject access request, and this can be made by you to your university, and it's typically done via your data protection officer. It's an online request form. You typically email an office. It's very simple. It's very easy. And as a research institution, they have to allow you to file an SAR. It's your data and you have every right to access it for any reason. For me, I basically asked, can I please have access to any emails that mentioned me by name, email address, or by nickname from X department. And I was able to get tons of information about a accommodations request that I had made to find out, one, the timeline of that request, if it had been implemented correctly, who had been involved in it, any comments they had made about it. So I could track the timeline of them implementing my request, and also see if it had been done correctly or not, and who had been involved in that. So I could go back and see, oh, this is where the breakdown occurred. This is where things had been done correctly. So you can see the value in that. An FOI, or a Freedom of Information request, is 100% kind of the same thing, but is a request of information on others. And this is a little bit trickier. You can only request this under certain circumstances, and you might need more evidence to access this. So this is you requesting information about other people related to maybe a situation that you've been in. That one, I would request maybe your advocate to help you walk through. You may just need additional evidence to kind of understand how you can better access that information. It's very similar to a subject access request, but it's just you getting that information about someone else. And that may have to do with a specific university complaint and needing information to say, this has happened, this is why I need this. Here's why I need access to it. Next slide. So we've talked about internal help from the student advice place. This kind of goes back to another thing that Chris was talking about in terms of identifying and self-identifying characteristics. There were some times where I think I felt a sense of, what's the word I'm looking for? Almost imposter syndrome, like maybe I wasn't disabled enough to deserve support in what I was asking for. And so I actually went to the EASS, which is the Equality Advisory Support Service. And I was talking to them, and they are a national helpline. So this is available in England, Scotland, and Wales. And they're there specifically to advise you on issues relating to equality and human rights. And so I used that as I use them as the service that they're intended, which is I wanted to know if they could help me identify kind of the situation I was in, and I guess better, figure out if this was maybe an issue of a breach of the Equality Act. So they can't offer legal advice, but they can give you advice when you believe something has happened to you that is a breach of the Equality Act. And I described my situation, I described my disability, and I even said, I think, to one of the people, I don't know if I'm disabled enough. And she goes, are you disabled? And I said, yes. And she goes, you're disabled. That's all that there's not an enough that you need to reach, and that was really validating. And it really helped me understand that, oh, I deserve to have this help. That's ridiculous that I would think I didn't. They also were amazing in helping me source important documents to help me support my complaint case. They even gave me templates to write a complaint letter to my university. So they are just a wealth of information. So one, they're very supportive. They're available to all of us. They have links to, I think, everything out there, and you can call them or you can email them. So if you're uncomfortable talking on the phone, please send them an email. I've found them to be fantastic. The next one is an ombudsman. So if your complaint is unsatisfactory within the university, so say you go through stage 1, stage 2, and for some reason the university complaint fails, or you feel that this is, it has just not gone your way, you're dissatisfied with the outcome, you have the opportunity to file with an ombudsman. This can be a city or local council area. And the ombudsman is an impartial third party that can hold organizations accountable to a certain extent. So even though an ombudsman ruling does not mean compensation for you and is not a legal ruling, it can be very helpful if your complaint is serious enough to need to go to court, or they look into just, local businesses, companies, and organizations. So we are kind of out of time, I think. If you want to go to my next slide, I'll just make sure I haven't missed anything super critical. I'll skip this one as well. I've kind of already talked about that. Yes, don't be afraid to follow up. If things go over a deadline, either for yourself or for one of the people that you're complaining against, don't be afraid to kind of follow up on that. And don't be afraid to kind of check in on that. So for example, I think the person I was complaining against was taking too long. I definitely followed up several times via email, or I had my advocate follow up for me to ask, hey, how much longer is this going to take? Which helps put some pressure on them to make sure that they're also following a timescale. Since, as Chris has said before, that can be very important to, going forward in any kind of complaint. Next slide. And I saw some people asking to make changes in their university, even if you're just making a change for yourself, or the change that you produce going forward is for, other people. If it's small, keep pushing forward. It's very worth it. Mine was a mixed success. So part of my complaint is still unresolved, but part of my complaint actually helped push the university to make changes that affected a lot of assistance dog users going forward. So I felt that that was a positive, and I've had a really great working relationship with our disability services and well-being coordinators because of the complaint that I made. So on the one hand, on the other hand, yay! So it's worth making a complaint to help push that needle forward. And yeah, that's what I've got. I'll stick around for questions, and I'm very sorry for going a little over there, Amelia. Thank you for reminding me.
Thank you so much, Julianne. No, it's really, really, again, like with Anna, I'm sorry for all the things in the process, but to have your perspective and your tips and things is so useful. And I think particularly the EASS group might be a really useful resource for people on this call. So I don't know if you can share in the chat their number or email address or something, but if not, we'll share it after the call in email form. I think we are running out of time, but we'll just go to a couple of questions, just because I know there's so many questions and I don't want people to feel like they've had some useful information. So I think this might be one for you, Chris. There's lots of questions about kind of how to handle it if a university is saying that it's unfair on other students if they grant a reasonable adjustment, and kind of how to handle that discourse, and that, because I think that's often an excuse that people are faced with.
Well, absolutely, and again, the duty makes it very clear that it's about removing a substantial disadvantage to disabled students. It's not about fairness to other students. It doesn't impact fairness upon them. And I'm very grateful to Anna and Julie's slides, and they're both beautifully crafted as well, for exactly pointing out that this is why, as per my slide and their slides, going to the student union is helpful, because it can be very difficult to self-advocate, particularly where you're being told that you're asking for more than is fair. And really, that's quite shaming in language, isn't it? Making you feel like you're wrong. Yes, you're disabled, but this is a bridge too far. So ultimately, in law, anything like that would be decided on the evidence. It is the case that, for example, competence standards are immune from the duty to make reasonable adjustments. So, for example, and this came up in the Abrahart case, the university said, well, it's a competence standard, her doing that talk, because that's the competency we're assessing. The judge wasn't convinced with that. The competency was how they could convey their findings. That was the competence, the actual academic scoring that they were getting. So that couldn't be adjusted, but the method of recording that could. She could have done a written piece of feedback or something else like that to achieve the same thing. So it's a bit like this point of fairness. There are certain limits to the duty to make reasonable adjustments, but those are hard to hit. So always go to your student union and get some advocacy for that. And also they should have a bit more understanding of other cases they've dealt with where they may have seen similar arrangements. So certainly get yourself some advocacy help at that point, so you don't feel like you're just fighting against a university that says you're being unfair.
Brilliant, thank you. I don't know if you can come in on this, or Julianne, a question about whether the subject access request, whether you can ask like the whole uni to search for your name or email address mentions, or whether there's narrowed scope with that.
I can answer on mine. So it works better if you narrow it to a specific department. especially because if you ask for your name or email address within the entire university, it will show up everything from the library books you've taken out to the emails that you've sent requesting, help from a student, a fellow student or professor. So if I would say if you have a complaint that you're making, or you have a specific department that has caused issue, narrow it that way. And you can make as many of these as you want. I don't even remember how many I've made at this point. You can just keep making them. So if you make one, so you can make a SAR for the disability department to see how your accommodations requests are processed. You can make an SAR for accommodation to see how your housing request is processed. You can make an SAR for the student union if you wanted to see how your clubs have been going. So that's the best way to go about it. A broad request to the entire university is going to turn up way too much. And the other thing too that I forgot is an SAR has to be answered within 30 days. So that's the other thing, talking about timelines. So yes, you could do it to the whole university, but I think you'd be disappointed having to sort the results. But Chris, you may have a different answer.
No, you exceptionally well, Julianne. I think really practical advice. So as Julia said, you're correct. You can actually do it legally. You can make the request to the whole of the university as the data controller. But exactly as she said, for practical reasons, that can often be very difficult. And secondly, there is an upper limit in terms of the reasonableness of the request. So if it does transpire that for the university as a whole, it would take thousands of hours of resources to kind of get all this, they can ask you to narrow your request to something more reasonable. You can, however, ask for internal correspondence as well, which I think is something we often do. So just to Julianne's point there, if you are narrowing on a particular incident or department, you may also want to request both the external and internal correspondence between the members of that, because it doesn't happen very often, but I remember once with a disabled student in Oxford, we found some pretty unfortunate phrasing, shall we say, from internal correspondence of the Oxford academics, which helped us get a complaint over the line. So don't hesitate to ask for internal correspondence, but yeah, you want to focus as much as you can, both for your own benefit and to avoid hitting that outer limit of unreasonableness.
Thank you. I think one final question just might be, Chris, if you could elaborate on your point about resulting, the indirect discrimination, the adverse impact on the individual.
Absolutely. So the problem is with talking about these rights kind of in a broader spectrum is that they are always based on individual circumstances. So of course, I think really, and I think, both Julianne and Anna's talks are really good at this, is that as a disabled person, when something arising from your disability is getting in the way, shall we say, when you're struggling because a particular policy is interfering with you or otherwise. And I see that in the questions, there's also been talk about, say, for a wheelchair user, heavy doors, for example. That would definitely fall within the second requirement of the duty to make reasonable adjustments. And although it's not a physical difficulty, it's a provision criteria of practice from the indirect discrimination. How does that go about? Well, I think whenever you're running into a difficulty, always raise it. And I think as well, never underestimate the power of a polite email. And what I mean by that is you don't always have to come at complaints from a position of anger. And sometimes it's best to come at them early, where you first get the problem. You think, oh, that could be a problem. The polite email first, or just pointing it out, saying, look, these heavy doors, for example, I'm coming into that. This is an issue. Now, you're understandable to get angry about it, justified to be angry about it. But just sending that email, don't ever think that it's not worth it, because it may very well be the university has no clue that it's having this unintended consequence. And you bring it up, even with a simple email, might lead to assistance both for yourself, but for others too. So I would say never hesitate to ask for the change to be made, even if you're not certain you have the legal justification to you. As my mum says, if you don't ask, you don't get. So don't hesitate to do that.
Thank you so much, Chris. Thank you. I wondered if Helen, who is the CEO of the Snowdon Trust, I don't know if you wanted to come in and say anything before we round up.
Thank you for asking, Amelia. I was so conscious of the time that I put something in the chat instead. But it's an opportunity to just say thank you to Chris and to Julie and to Anna for a really brilliant session. I think all of us here have enjoyed it a lot and gained so much from it. I just wanted to say that the Snowdon Trust Disabled Students UK and the Disabled Leaders Network have been talking a lot about how we can develop more information about legal rights so that disabled students know what their rights are and have resources that help them act on them. So we will be developing these, and we really want to have input from students to make that work. So I think the easiest way to drive that forward for now is to say watch out for our socials, where we will ask for support going forwards.
Thank you, Helen. Yes, I would just add to that and say that as a Disabled Leaders Network, we will be looking to bring on new members in 2025. So if you would like to join the network, as you have attended today's event, you will be eligible to apply. There is an application process, but you will be eligible to apply having attended today. And we do, lots of work in this area, and it's something that we're developing, so you can be involved from that point of view. But I would also say we will be following up with emails after this event, and so please do get in touch if you have ideas, or as Helen said, keep an eye on our socials for more specific requests, and if you have any questions, please, I'll put my email in the chat and you can get in touch with me. And I would also say that there are some great resources that people have been sharing in the chat, so please do check those out as they might be useful. And this is kind of the first of many events in this area and many activities, as Helen was saying. So if you have, I think we might use some of the questions that have been submitted to maybe do some more specific sessions. But if there are some kind of particular areas you would like us to focus on as regards disabled student rights, then please just get in touch. So all that's left to say is thank you so much to Chris. We really appreciate you giving up your time, and thank you to Julianne and Anna for all you do in the network and for sharing your experiences today. We really appreciate all of you being here, and thank you to our access providers as well for helping make sure our event today was as accessible as possible. If you are in the Disabled Leaders Network, we will be having a closed group discussion on a separate link after this call, which you should have been sent via email. But if you are not part of the network, I really hope you will keep in touch, keep abreast of what we're up to, and please do get in touch. We really appreciate all of your time today in this lunchtime. So yeah, thank you so much.